Watching Addleshaw Goddard's employment channel. In this week's headlines, there's to be more protection for employees dismissed for political opinions or affiliations. And we report on some new guidance for employers on handling religion and belief in the workplace. Also in today's programme, we catch up on a case from last year about indirect age discrimination, and we follow up on our last programme by looking at the new draft Acas Code of Practice on settlement agreements. First up today then, a change to the law on unfair dismissal. This comes after a recent ruling from the European Court of Human Rights, or ECHR. You may remember the case of Redfearn and United Kingdom, which we covered back on the channel in November. Briefly, Mr Redfearn was a bus driver who'd lost his job way back in 2004 after being elected as a local councillor for the BNP. In November last year, the ECHR found that the UK's qualifying period for an unfair dismissal claim, which at that time was 1 year but is now 2, meant that the UK hadn't sufficiently protected Mr Redfearn's Article 11 right to freedom of assembly and association under the Convention. The ECHR asked the UK to take reasonable and appropriate measures to protect all employees, including those with less than a year or 2 years service, from being dismissed on the grounds of political opinion or affiliation. Although there was a rumour that the UK may appeal the ECHR's decision, it now seems that the government's decided against this. Instead, the Employment Rights Act 1996, or the ERA, will be amended to remove the qualifying service requirement for an unfair dismissal claim where the reason for dismissal is political opinion or affiliation. However, any dismissal for this reason won't also be automatically unfair. I asked Jamie Hamnett then, a partner in Addleshaw Goddard's employment group, what he thought about this forthcoming change to the law.
Thanks, Helen. It's certainly an interesting development. I think it's often easy for employers to simply look at a situation with an employee who doesn't have normal unfair dismissal rights and quite quickly jump to a decision that they're simply going to dismiss without a process, without always taking into account what the underlying risks might be. And this development goes to the very heart of that. So we're all quite used to advising clients on discrimination risk and the importance of, in those circumstances, following a process to divert attention away from the discrimination claim. What this development means, of course, is that political opinion and affiliation is going to be added to as one of those exceptions to the normal rules. Now, I guess in practice, it will be a fairly rare occurrence for an employee to have sufficient grounds to succeed on that sort of a claim. Having said that, of course, all practitioners, HR and legal, will be familiar with employees who try it on, shoehorn that type of allegation into proceedings in order to try to protect themselves and or raise the stakes. How to mitigate against the risk? I think it's first and foremost important that the employer establishes the facts and tries whatever they can to establish whether or not there's a risk of a political affiliation, political opinion claim having legs. If there is, and that's not the principal reason for dismissal, let's say it's a conduct reason or a capability, performance reason, the employer needs to follow something of a fair process. And it's often not difficult to mitigate the risks significantly without following a terribly exhaustive process. Needless to say, it's something on which employers should take advice when the need arises.
Thanks, Jamie. It's worth saying that the change is due to come in 2 months after the Enterprise and Regulatory Reform Bill receives royal assent, and it will apply to all dismissals after that date. Next up then, we recap on a case that we looked at last year, the case of Homer and Chief Constable of West Yorkshire Police. Now this went all the way to Supreme Court, where Mr Homer successfully argued that requiring a law degree to reach the top tier in a new career structure was indirectly age discriminatory, since because of his age, he wasn't able to obtain a law degree before he reached retirement age. However, the case at the Supreme Court was sent back to the Employment Tribunal to look at whether the requirement for that law degree could be objectively justified. Basically, this meant a tribunal assessing whether or not it was a proportionate means of achieving a legitimate aim. Now, the update is that the tribunal has found that it couldn't be objectively justified here. Mr Homer's employer, the police, they weren't able to show that the requirement for the law degree was sufficiently related to their legitimate aim of recruiting and retaining the best staff. And they weren't able to show that they considered alternative ways of meeting that aim. So Mr Homer was successful in his claim for indirect age discrimination. I thought I'd ask Jamie Hamnett whether this case throws up any learning points for employers.
Thanks, Helen. It's first and foremost, it's good to get a decision in this case. We've been looking out for it for quite some time. It provides a very helpful reminder of how the justification test in indirect discrimination claims works and is applied in practice. Looking at the facts, first of all, of this particular case, I don't think we were really expecting it to go any other way. If you think about a guy who's worked within the police force for some 25 years and has got masses of experience, it never felt right that the fact that he didn't have a qualification, a law degree qualification, meant that he was incapable of carrying out the role which he aspired to carry out. The police force found themselves in this, if I dare say it, slightly daft situation where they were willing, on paper at least, to entertain applications from people who've got a law degree who wouldn't have had anything like the same experience that Mr Homer had. So on the face of it, that's not a great surprise. A practical pointer to come out of that, we often advise employers when they are thinking about advertising a role to test whether or not a specific qualification is absolutely a mandatory requirement or whether it can be tempered slightly. So what you could say is the qualification or, as an alternative, relevant experience. And of course, those same principles apply generally to assessments of risk in relation to indirect discrimination claims. And in terms of some practical help, I always encourage employers to think about what it is that they are trying to achieve, and then, having identified their preferred approach, firstly, test whether or not that approach will actually get them to the conclusion that they are trying to achieve, and then secondly, to test very carefully whether, if that particular approach is likely to result in an indirect discrimination risk, whether there are any other approaches, any other ways of achieving the same target, the same goal, in a less discriminatory way. Why is that important? Because if an employer can show that, it will be hugely helpful in the event that the practice criterion provision can be justified in the Employment Tribunal.
Thanks, Jamie. To finish up for today then, we leave you with a couple of updates from our last two programmes. Last week, we mentioned that Acas would soon be releasing a new statutory code of practice on settlement agreements. Well, the draft code's now out. Highlights include settlement offers must be required in writing, employees should be given a reasonable period, suggested as 7 days, to consider those settlement offers, and employees should be allowed to be accompanied at settlement discussion meetings. Where there's improper behaviour, we know that confidentiality won't attach to the discussions. Up till now, the question on everyone's lips has been, well, what's going to amount to improper behaviour? The code now suggests that this will include all forms of harassment, including intimidation through offensive words or aggressive behaviour, and this applies to either party. It'll also include physical assault, perhaps unsurprisingly, as well as any discrimination and undue pressure from one party to another. In case you're wondering what undue pressure is, the code also goes into that detail. Examples include perhaps not giving employees 7 days to consider a settlement offer, perhaps reducing that offer during the 7 days, or where employees threaten to undermine the employer's public reputation unless the employer agrees to sign. The consultation closes on the 9th of April, so please click on the link at the bottom of the screen if you'd like more information. And finally for today then, following a decision from the ECHR in January about handling religion and belief requests in the workplace, the Equality and Human Rights Commission has produced some handy guidance for employers. Advice included in the guidance includes only question an employee's belief in the most exceptional cases. So for example, where it's very obscure, perhaps seems objectively unreasonable, or there's genuine doubt about the sincerity of the employee's belief. Also, employers should take all requests based on religion and belief seriously, and they should avoid making assumptions about the significance of a religion or belief, or perhaps disregard a request just because it's only made by one employee. The guidance also includes a set of frequently asked questions with answers, as well as examples of different requests and how employers can handle them. So if you'd like to take a look, the link to that is also at the bottom of the screen. So that's all for today from Addleshaw Goddard's Employment Channel, in a programme where we've looked at dismissals for political opinions, age discrimination, settlement discussions and accommodating requests based on religion and belief in the workplace. Thank you for watching and goodbye.